Last week, Supreme Court Justice Clarence Thomas broke his silence to ask a question during oral argument. This would make it the second time in 13 years that he's spoken, once in 2016 and before that in 2006, if you're keeping track, which clearly I am. And while his silence has been deafening, we now know that whatever may be occurring underneath that say-nothing demeanor is deeply unsettling, like a recent dissenting opinion. In it, Thomas questioned the landmark 1963 ruling in Gideon versus Wainwright. For those who may need a refresher, please go get the brilliant Gideon's Trumpet, written by the late New York Times columnist Anthony Lewis, husband of former Mass Supreme Judicial Court Chief Justice Margaret Marshall. But until you do, Clarence Earl Gideon was a poor drifter who was arrested for petty theft and breaking and entering in 1961. Because he could not afford to pay for an attorney, Gideon was forced to defend himself at trial. The judge found him guilty, and he was sentenced to 5 years in prison. While incarcerated, Gideon wrote a letter to the Supreme Court petitioning them to take up his case. He argued that his constitutional right to an attorney was violated. The Supreme sided with him. And from that point forward in state and federal cases, an individual whose liberty is at risk has been entitled to a court-appointed lawyer at no charge if he or she can't afford one of the central pillars of our justice system. But not for Thomas, who referenced the prior dissent, which stated the Sixth Amendment as, quote, originally understood and ratified meant only that a defendant had a right to employ counsel or to use volunteered services of counsel, and that the right to effective counsel is a concept the Supreme Court later expanded on. Therefore, he said, courts should tread carefully before extending our precedents in this area. That's legalese for the right to a lawyer, regardless of ability to pay, does not exist, even if the defendant faces the death penalty. What's even more disturbing about Thomas's extremist opinion is that Justice Neil Gorsuch agreed with him. So both believe it's okay to deprive a defendant of effective counsel even when capital punishment is on the line. You know, Clarence Thomas grew up poor in a one-room shack with dirt floors and no plumbing. I'm guessing his family couldn't afford a lawyer. Had they needed one for not the first time, Thomas should be ashamed. What do you think? Email us, tweet us, share your thoughts.